Hello everyone, welcome to lesson 4 of drafting pleadings and appearances. And the content of this lesson is common for both the old and the new syllabus, so I suggest both the syllabus students can actually benefit from this session. So this is a broad coverage. So if I talk about the coverage, we will discuss on the agreement of sale, building contracts. Sorry for the repetition, but yeah, we'll discuss on the commercial agency contracts, collaboration agreements, arbitration agreements. We'll also have a detailed discussion on guarantees, hypothecation agreements, outsourcing agreements, service agreements, e-contracts, and then leave and license, will and gift. This is the entire coverage of this lesson. Right. So before I take you forward with the rest of the topics which we have to discuss in this video, so it is very important for you to understand the concept of attestation, registration, and stamp duty, which is common for any contract, right? So the requirements might change, but the meaning of these things won't change for each of the contracts. So what is attestation? Attestation means witnessing. So when you sign a contract, who witnessed your signature, who witnessed that you signed at that time? That is very important. Generally, the Indian Contracts Act does not mandate for attestation. However, there are certain contracts which require mandatory attestation. For example, will deeds. So other respective codes like Indian Registration Act and other acts will talk about the requirement of mandatory requirement of attestation. Where there is no mandatory requirement of attestation, you need not have one. That is about attestation. Now coming to registration. So registration means signing the document before a government authority who is called as registrar. So usually registration is also not mandated for all contracts, but the Registration Act mandates registration for contracts, the agreements where interest in immovable property worth more than rupees 100 is being conveyed. So usually for conveyances, registration is mandatory, right? And to understand what is conveyances, our lesson 1, we had a detailed discussion on it. The third important aspect is stamp duty. So stamp duty is nothing but what is the amount of duty you pay to the government for the purpose of this entering into this agreement. So stamp is a state subject. Even though we have a central act, Indian Stamp Act, the power to collect stamps have been assigned to the respective states and even the power to decide the quantum of taxes. Hence, when you're entering into a contract in a particular state where you're affixing a particular state's stamp paper, then be assured that that particular state had allowed, or rather look into the stamp duty which is supposed to be paid for that respective agreement in that particular state, right? So these are the three things which you need to keep it in mind. And for every contract you sign, or for every contract you as a company secretary approve in your company, think whether it requires attestation or not, think whether it requires registration or not, and whether it requires stamp duty payment or not. This is very important. And attestation, I suggest it can be there for every contract. There is no hard and fast rule, right? So having a witness is very important because it becomes easy for you to prove tomorrow in the court of law. Hence attestation is recommended, whereas registration and stamp duty is not generally recommended, in the sense that it's not like a pro bono, you do it just like that, give money to the government. Companies won't like it, right? So you have to save money wherever it is possible. Hence, when it comes to registration and stamp duty, always make sure that you're not attracting huge amounts of huge amounts of stamp duties on your documents, right? So let's move forward. Right. So talking about agreement of sale, it is very important firstly to differentiate it with a sale deed. The difference between an agreement of sale and a sale deed is that an agreement of sale is a contract, whereas a sale deed is a conveyance. So we have seen what is a contract and what is a conveyance, right? So this is fundamentally the difference between an agreement of sale and a sale deed. So what will happen in an agreement of sale? So in an agreement of sale, essentially the parties come to a agreement that one party is agreeing to sell a property and the other party is agreeing to buy a property. So let us take a simple example. Imagine this is the property, a piece of land which is proposed to be sold by A. So A is the owner and it is proposed to be sold to B, who is the buyer. Now, but B needs 6 months time. Why? Firstly, to get the money ready, and secondly, to look at the documents, to verify the documents. So what does B say? B tells A that I am ready to buy this property at the price which you have proposed. However, I need 6 months period of time, but at the same time I do not want any ambiguity. I need to arrange money for which I have to sell some other properties of mine. Hence, I don't want you to change your words later. So the A says yes, sure. Then what should they do? First thing, can A simply sell the property to B on the mere promise of B? The answer is no, because for a sale deed to be effectuated, you need receipt of money for sure. Correct. And hence, you cannot execute a sale deed, you cannot convey the property to him. So you have to wait for 6 months. So what will you do? You enter into an agreement of sale. So what happens essentially in agreement of sale? A has a property, A is the owner of a property. B is willing to buy the property. Both of them agreed on the terms. However, they would be buying the property at a proposed date. Correct? Hence, here the capacity of A is a proposed seller, capacity of B is a proposed buyer. So in their respective capacities, they enter into an agreement of sale wherein the recitals clearly capture that A is the owner, B is willing to buy, and this is what is the contract which they are trying to enter. And in the terms of the contract, we will mention every important factor as to the compliance, all the essential elements under the Indian Contracts Act have to be met. And similarly, we will also provide within what time the registration will be, registration of the sale deed, in the sense that within what time the sale deed has to be entered into also will be entered. In our example, it is 6 months. Next, in this 6 months, B can ask for possession as well. If B would pay some advance money, which is also called as earnest deposit or earnest money, even if advance is given, at times there is practically people would also give possession to the proposed buyer, and later the buyer will buy off the property. So if at all any earnest money is given, that also has to be captured. So this will be captured in the clause of consideration. So the receipt clause captures this money, the receipt of the money, right? And then what will happen if the sale deed is not registered? So imagine a scenario in 6 months the prices have shoot up, but B agreed to buy it only at a predetermined price. So A will not be willing, right? A will have 10 other buyers who are ready to buy at that high price. So there may be a chance that A might fail to execute this contract. So that amounts to breach of the contract. So failure to register sale deed, which has been agreed in agreement of sale, will amount to breach of contract, and the consequences of breach of contract also has to be drafted in your agreement of sale, right? So I'm not going into the practical aspects of this drafting as to how you draft, how should the clause come and all, because that takes a lot of time. So that we do as part of our course, which is purely aimed at providing the practical exposure and also drafting skills to the students as to how to draft, how to approach these kind of contracts. However, in the interest of all, the only suggestion I can make is go back to lesson number 2, where I have taught you how to start off with the draft. So where I gave a bit of an indication as to how to draft things, so you can use that as a format and then develop on it, right? So let's move forward. Building contracts. The reason why I clubbed agreement of sale and building contracts when you have seen the contents is that usually whenever any home buyer is buying a property, the main two documents which they will enter into is one, an agreement for sale, and second, a building contract or a development contract. So now let us look into this building contracts. So usually these building contracts, as the word suggests, contracts are governed by the Indian Contracts Act 1872, and the parties are builder and the owner of the land. So now imagine A is owner. He doesn't want to sell the land, but he wants to develop buildings in this land, right? But he can't do it on his own. So what does he want? Whom does he want? He needs a contractor or a builder. So how does it happen? How does this building contract happen? So A is the owner of a property. He wants a third party, that is a contractor, to come and construct building over it. For which, what is the first thing A should do? That is the owner. He should hand over the possession of the possession to the builder, that is the contractor. Correct? And such contract between the owner and the builder to construct a building on a piece of land is what is called as a building contract. And such building contract can be executed in two major ways. One, purely a works contract. So what is meant by purely a works contract? Over there, the owner will have the entire title over the property. Only the possession will be transferred to the builder for the term or for the time period during which the construction has to be done. And moment the construction is completed, that possession will go back to the owner. Correct? So usually it is when you want to construct your own house, when you want to construct a farmhouse for yourself, or when you want to construct an office building for the purpose of your employees or for the purpose of your businesses, such things come under this works contract, wherein the builder will purely do it as a service. It would be a pure service on the part of the builder. So here the consideration part is that usually lump sum amount would be paid, agreed to be paid, and or it would also be a kind of a cost plus contract. That is, the builder will incur the cost, and over and above the cost he would say 30% would be my charges for the services which I did. So it can be either ways, and this consideration plays a crucial role in a building contract. So one suggestion I can give you here when you're drafting a building contract is that you should clearly describe the owner and the property, which again, as I said in lesson number 2, I've given clear instructions as to where you describe a property and all. And few people who have shown interest, who wanted that the standard format, I've also emailed the same to them. If you are interested to have that format of a particular draft, like which is common for any draft, you can still show your interest. The form is still there under the description, right? Fine. So coming back to the concept of building contracts, under the building contracts, if you you need to remember that when you're drafting it, the property, the extent of the property on which the building is to be constructed has to be clearly laid down. Along with it, your instructions to the builder as to the quality of materials which he is supposed to use. That is very important. Whatever the quality which you want the builder to use, in terms of right from the terms of the cement, bricks, paints, doors, flooring, marbles, all of this will come under a respective schedule of furniture and fixtures, or schedule of fixtures usually, where you will prescribe what are all the things which he has to use, and also schedule of materials which will prescribe the quality of materials to be used by the builder. So that is very important, and you have to make sure that that is there, because if such quality is not met, you can file for a breach of contract, right? Second is a development agreement. So as I told you, usually home buyers, if you see large complexes in any cities, the builder would be one, owner would be separate, and both the building and owner and the builder together will sell away the flats to the home buyers. So here what happens is, the builder will construct the building as per the design of the builder, and he will transfer possession only over a limited extent of property to the owner. So usually what happens, A owns the property, these are the buildings. So here builder will not take any consideration from A for the construction of the property. That is, in cash there is no consideration taken. However, builder will take title over part of the property. So what builder tells the owner is that, see boss, you need not pay me any even a single penny for the purpose of construction. I would incur every cost for the purpose of construction. However, post construction I will give you title only over half of the property. Rest half of the property I would enjoy the title over it. So here the consideration is in kind, not in cash. So you would get it as a title over the property, correct? And the builder will construct the building at his own expense in return for title over certain extent of building, right? So usually for gated communities and for other respective like complexes where you want to sell for commercial or residential purposes, this is how it usually happens, right? So as a home buyer, as a company secretary, usually under the practice of RERA, that is Real Estate Regulatory Authority Act 2016, this concept of agreement for sale and building contracts have attained huge importance. And RERA is also an area where company secretaries also can practice, right? So we also have series of videos on RERA which you can follow for you to understand what is RERA and how these can be practically used. However, that is not much of importance for your exams, but still a suggestion. Let's move forward. Now, commercial agency contracts. So what are these contracts of commercial agency? So it's, the best example of commercial agency contracts is the LPG gas cylinders which are being delivered right at our houses. So all those agencies we call, right? So they are nothing but the commercial agents who act on behalf of the principal, that is the HP gas cylinders, HP gas, right? So applying the same logic here, there would be one guy who is called as the principal, correct? And the other guy is called as the agent. So what is the principal's role? The principal's role is to instruct the agent to do things on his behalf. So in an agency, the agent usually does things on behalf of a principal, and that is the reason why for every act of the agent, the principal will be made liable. Correct? So now these are actually the things which you would have read even in your uh, foundation, the CS foundation, or for the CS students in the CPT. In the mercantile law, we learned on agents, right? So it is basically based on the maxim which is qui facet per alium facet per se, which means he who acts through another is deemed in law to do it himself, correct? So if you are acting through another, it is deemed that you did it yourself. So principal is the one who acts through the agent, but it is deemed as if principal is doing it himself. This is a very important principle in a commercial agency contract. So whenever you are drafting a commercial agency contract, it has to be clearly established the details of the principal. You have to define who is the principal, who is the agent, and that the principal is appointing the agent to do acts on the behalf of the principal. The words on behalf of the principal have to come in your commercial agency contracts. And the key ingredients for any commercial agency contracts are, firstly, the agent should accept, right? So the signature of the agent is mandatory. Of course, it goes without saying. And for consideration, the consideration in case of a commercial agency contract is called as commission, right? So it's not usually salary based, it would be commission based. Yes, it can be fixed as well, but we term it as, in technical terms, it is called as commission, correct? And there shall be a clause which shall clearly state that all the acts of the agent shall be ratified by the principal. So that is what is the third important point. So all the acts of the agent shall be ratified or shall be deemed to have been ratified by the principal. This is how you have to draft a clause. And the commercial agency contract should clearly specify what is the commencement of the agency and when does it terminate. Because during this term alone, the acts of the agent will bind the principal. If the agency is terminated, and even then if the agent is doing any act, then that would no more bind the principal. That has to be remembered. Next, you have to clearly describe the role of the agent. If it is dealing with services or the goods, you have to clearly describe such services or the goods. And also, very important, which I consider it really crucial in any contract, is to prescribe the territory in which he shall act as an agent. If you say Mr. B is appointed as an agent in the territory of Maharashtra, state of Maharashtra, then he cannot cross that state of Maharashtra. All his acts shall bind the principal only if his acts are extended to the state of Maharashtra. If he does anything apart from if he does anything beyond the territory of Maharashtra, that would not bind the principal, and also that would infringe his duty as an agent. Correct? Next, in addition to the commission, the agent will also usually be eligible to for the purpose of reimbursement of the expenses. So your clause should also be containing on the purpose thing. There should also be a clause on reimbursement of expenses which the agent has incurred. Now, another important aspect in a commercial agency contract is delegation of or rather assigning of the duties of the agent. So any obligation cannot be assigned unless the three things. One, the nature necessitates such assignment. So it is so much in the nature of the business that you have to assign. Then that is fine. Where it is a custom of the trade, then also it's fine. Or where the contract of agency clearly allows you to assign. Let us say you have been assigned a contract to sell the goods in the territories in the state of Maharashtra, but you have further assigned it to some other agency to do it, right? In a particular district of Maharashtra, if the respective business requires it, because you cannot actually spread your wings across every district. Maybe you do not have in all the districts, only in half of the districts you have, in half you don't. So for the rest of the half, it is reasonable for you to give that responsibility to some other person or some other agency. Hence, such things are allowed, right? So that is what is the concept of assigning of the responsibility of an agent, right? So now let us look into the definition. So section 182 of the Indian Contracts Act 1872, it defines the terms agent and principal. So I'm reading it out for you in the interest of everyone. So an agent, that is A, is a person employed to do any act for another. So here for another we mean for the principal, right? Or to represent another, similarly to represent the principal in dealings with third persons. So whenever you're dealing something with third person, so these are all the third persons and you're acting on behalf of the principal in dealing with such third person. So here the person for whom such act is done and or who is so represented is called the principal. So P stands for the principal. So here this image I wanted to focus very important attributes of a principal and an agent. Principal is fundamentally liable for the acts of the agent, and he shall be a person who is major and of sound mind. Whereas an agent need not be a major, even a minor can be an agent. That is one of the exceptions for a minor. And a principal acts specified to agent by the principal. So principal will specify certain acts to the agent, and for which principal shall be held liable. That is what is the contract all about. And the agent will act on behalf of the principal for all such acts. So this is what is fundamentally a commercial agency contract. Let's go forward. Now, when you want to terminate such contract of agency, what should you look into? You have to look into the Contracts Act section 201, wherein it says that a principal can revoke the authority of an agent. An agent can renounce himself from being an agent. Where the business of the agency is completed, then yes, it amounts to termination of an agency. Where either of them are dead or they become unsound, and where the principal is adjudged and insolvent under the provisions of any act. So where the principal has been adjudicated as an insolvent, and then also the contract is deemed to have been terminated. So these are all the grounds for termination of a contract of agency. Now another important concept is agency coupled with interest. So what is meant by agency coupled with interest? It is a contract where even the agent himself is personally benefited out of that particular contract. Apart from commission, he himself has some kind of an interest over that particular contract or a particular business. In such a case, an agency cannot be terminated. So an agency coupled with interest cannot be terminated unless an express contract for in that regard has been clearly been made, right? So this is a very important point under contract of agency. Now, where there is a concept of consideration, it need not necessarily be a requisite for an agency contract, right? Which means absence of consideration does not mean an agency is void. So under the essential elements of a contract, consideration is the foremost and important one. But there are certain exceptions where you need not have any consideration. For example, gift, there need not be any consideration. Similarly, in case of an agency, there need not be any consideration. It's an exception provided under section 185 of the Act. Now, coming to del creditor agency. So del creditor agency is when the agent takes the responsibility of the payments or responsibility of the performance of the contract by the buyer. So let us say A is the principal, C is the buyer, and B is the agent. Now, for the contract, for this contract, B will get a commission irrespective of whether C pays to A or not. Correct? However, B will get a del creditor commission if B ensures that C pays to A, which means B takes the responsibility of the payment, which again means that in case of non-payment by C to A, B shall be held personally liable to make the payment. So this is called as del creditor commission. So on del creditor commission will usually be higher than the general commission which will be paid to the agencies, and the reason why is it is an agency coupled with the risk. So there you have a risk, and for such risk, a del creditor commission shall be paid as a premium, right? So this is all about commercial agency contracts. Let's move further. Collaboration agreements. So collaboration agreement is a kind of an agreement where the basic entity, the type of the corporate entity does not change, right? So what I mean to say here is there would be two organizations. Let me take an example. A Limited. Okay, instead of A and B, let me give it this way. A recent example which can give you a very good understanding. Facebook and Reliance Jio. So we have seen the news that Facebook has signed certain agreements for purpose of investing in Reliance Jio. So what does it necessarily mean? So they are basically trying to come forward and do something, right? So even though the investment is a phase, behind that they are actually entering into a lot of collaborations wherein they want to integrate the shopping platform of Reliance onto the Facebook platforms of WhatsApp, whereby every household can easily shop for their groceries. So that is one major concept. So over here, Facebook and Reliance Jio have collaborated, or they are planning to collaborate. So, and what is the output of this collaboration is a business which is mutually beneficial for both. But are they forming a new entity in order to collaborate? The answer is no. So that is what is called as a collaboration agreement, where these are entered by consenting organizations to share resources for accomplishing a mutual goal. I hope this example helps you understand that. Correct? And the object is to exchange usually the technical know-how, technical designs, drawings, technicals, and these are standard. Okay, standard collaboration agreement where usually technical science teams will work together, right? For example, you have a patent, I don't, so you share the information of it. I do the business in India, I give you back 50% to you, I retain 50. So this is what is a collaboration again, right? So there are various areas where you can collaborate, and one example I've given you is the Facebook and Reliance Jio for you to understand the meaning of a collaboration agreement. So in the subsequent slide, I will take you through how a foreign collaboration agreement has to be entered into. Now, coming to foreign collaboration agreements. So, as the name rightly suggests, it is an agreement between a party within India and a party which is abroad. That is what is a foreign collaboration agreement. So, in the previous slide, we have understood what is a collaboration agreement. So, where two parties come together to collaborate on a common objective for a mutual benefit. So, for which, in case where you are entering into a collaboration agreement with a foreigner and where usually patents are involved, the scientific or technical knowledge is involved, the guidelines, I mean, RBI has given certain guidelines to be complied. So I will take you through what are all the guidelines. So it will be quick through to the guidelines, and all these 16 guidelines which we are going through now should form part of your agreement which you are drafting. So it has to state that all these have been met, or all these are basically the essential terms and conditions of a foreign collaboration agreement in India, right? So what is it? Number one, where the people, there is an equity participation involved, then such shares shall be bought in cash and not for any consideration other than cash. Which means just because I'm giving you technical know-how, in return of it, you should not give me shares. If I am investing in shares in your company, in that case, such shares has to be taken at cash. So I have to pay you cash and get the shares. That is the first condition. Second, whatever the amount I pay you for technology transfer, I is the Indian company here, myself Indian company, Indian party, imagine yourself as a foreigner. So if I am giving you some money for the technology, you are transferring it to me through our collaboration, I should give you in 3 equal installments. 1/3 I pay you upon approval of central government, because all these foreign collaboration agreements shall be approved by central government. Second shall be on transfer of the technical documents from you to me, and third shall be on the commencement of commercial production. Correct? And the royalty which I pay you shall be computed on this formula. So remember this. This is the formula which they have given for the purpose of computation of royalty. Right? Now, and what is it? It is self-explanatory. Like net ex factory selling price minus all the excess duties you pay has to be deducted. Imported components, the cost has to be deducted, and on that amount you have to pay an amount. I mean, on the determined value you have to pay an amount of 3 to 5%. It shall not exceed more than 5% as well. Correct? And yeah, coming to the term of the contract, such term should be for a maximum of 10 years, and any extension you need to take approval of the central government. And if you are making remittances to the foreign collaborator, that is foreign collaborator is making money out of it, it has to be only on prevailing exchange rates. You cannot enter for a fixed rate of exchange at the time of for the purpose of paying of royalty. That is not possible. And if you want to sublicense it into any other Indian party, it is subject to the central government's approval. And of course, your foreign collaboration agreement should not restrict it. So it should give a right for the Indian parties to sublicense it. And you can export to, the foreign collaboration agreement should not restrict me from exporting it to any country. However, where there are certain countries in which the foreign collaborator has, the foreign party, that is you have certain contracts in such countries, yes, there I cannot be allowed. For example, you have contracts in UK. So in UK, you have given a supplier only, you have entered into a foreign collaboration with someone else. So I cannot supply there in UK, but in rest of the world, you should not restrict me. So that is what is the condition. So your clauses should be very particular. They should not have such restrictions. And for the purpose of procurement of capital goods, you should not restrict me. You should not say you have to procure only from me or only from the foreign country. So I should be free to have control over my pricing facility and my selling arrangements, and also on my sourcing of raw material. You should not impose any conditions on that. And in case it requires a lot of technicians from either side, from you or from me, suppose I might send my people to your country and you should train them there, or you would send your technicians to come here to India and train my employees, or to guide us. In such cases, the number of such technicians, the terms of service of such technicians, and the remuneration of such technicians shall be approved by the Reserve Bank of India. Next, the provision for adequate facilities for training of Indian technicians for research and development has to be made. So the agreement should clearly contain that the research and development of Indian technicians shall be allowed and also shall be supported. And if it is an item of manufacture which is patented in India, then the royalty or the lump sum to the collaborator should make provision for compensation of such patent until its expiry. So where the foreign collaboration has been entered, I'm making you the payment of royalty. So till the patent has been expired, you should give me. So this usage or the royalty should be allowing me to use your patent also, correct? And even after the expiry, without making any additional payment, I should be allowed to make use of your payment. So even after expiry, here I mean expiry of the agreement. So if the collaboration agreement has expired but the patent is still in force, for the unexpired period also you should be letting me use your patent for the same compensation I pay earlier, right? Next, if the necessity for any consultancy arises, that is, if I have to take any consultation from someone for an expert opinion, and if the foreign consultancy becomes ultimately essential, in such cases, I might prefer a foreign consultancy. But you should not restrict me from not going to an Indian consultant. So usually my Indian consultant should be my primary consultant, and you should not restrict me for that. And just because I'm using your technical know-how, it doesn't mean you insist me on use of your foreign brand names on the products in India. That is not possible. However, where I sell the product in other countries, yes, there is no such objection. You can restrict me, or you can tell me where I can use the brand name. What brand name should I use on the products which I export to other countries? And remember, all these foreign collaboration agreements should be subjected to Indian laws and should have been approved by the central government. So there should be a clause in the foreign collaboration agreement which says this agreement and the terms of conditions thereof shall be subject to the approval of the central government. So this is about a foreign collaboration agreement. Again, as I am keep on repeating in our classes, so I'm not going into the detail of showing you the draft, how it has to be drafted, because that forms part of our course where we give you the detailed aspects. However, as part of your study, you should remember that such foreign collaboration agreements you need to draft, keeping in mind all these 16 points, right? Let's move further. Now, coming to arbitration agreements. So what is an arbitration? Arbitration is an outside court settlement, right? So usually there are two ways by which you can enter into an arbitration agreement, either as a clause in your agreement. So in all the contracts we have seen till now, you can have a clause which is arbitration, or it can be a separate agreement. So where you enter into a separate agreement. So it can be of two ways. One, a clause. Second, a separate agreement. And apart from this, it's important to see as to how this arbitration agreements can be drafted, right? So arbitration agreements will usually be drafted between the parties, that is the one who is, between whom the contract is entered into, and this arbitration, they will have to decide when this arbitration will be triggered, right? So usually for any arbitration to be triggered, there shall be a dispute and submission of such dispute before a third party for submission, and such third party is called as arbitrator. So the parties will submit before an arbitrator, and apart from this, the arbitration agreement shall contain the venue of arbitration, the language of arbitration, and the seat of arbitration. So see here the usage of words venue or place of arbitration we call. So that is nothing but the physical area where the parties are agreeing to meet in order to arbitrate. Right? For example, both the parties are from Hyderabad, then they might say Hyderabad shall be the place of arbitration. But seat of arbitration means applicable law. The parties can agree to apply any other law apart from the domestic law also for their dispute. So that is what is called as seat of arbitration, right? And next is called as language of arbitration. Language of arbitration is what is the language in which both are comfortable. Let us say both are only Marathi speaking, then they can make language of arbitration as Marathi only. Similarly, the arbitrator also someone who should know Marathi. It's up to you because you are deciding how your dispute has to be resolved. That is the principle behind arbitration. The arbitration agreement is like two people decide what will happen and how they want to resolve their dispute between themselves. Hence, it is mostly flexible. And such arbitration agreement should always be in writing, signed by the parties, and you should state the entire procedure for arbitration in addition to what the contents are. Right? Now, arbitral award. So the output of an arbitration is an arbitral award. So where two parties submit before an arbitrator their disputes, so the arbitrator will listen to both the parties, both their contentions, and then the final output which he would pass is what is called as an arbitral award. And it shall be in writing, and all the members also of the tribunal, the arbitrator or arbitrator or a tribunal. So where there are three arbitrators, then it is called as arbitral tribunal. So arbitrators can only be in odd numbers. It cannot be in even numbers. It should be either 1, 3, sole arbitrator, or tribunal 3, or 5, 7, 9. It shall be in odd numbers only. And such tribunal or the arbitrator shall state the reasons also on which such has to be or such odd award has been made. However, an arbitrator need not make an or a tribunal need not give the reasons if the parties agree that no reason need to be given, or the award was on agreed terms only. So where both the parties have agreed on certain things and the award was also passed on the same thing, and there's no point of giving reasons for it, right? So these are the two exceptions. Now, so these two do not consider as exceptions. These are additional things. The arbitral award shall mention the date and place of arbitration where it has been given, and it has to be certain, final, and its implementation must be possible. So what is the meaning of it? The arbitral award should not be ambiguous. It has to set what each party should do. Okay, so this is the award. A has to pay 50,000 rupees as penalty to B or as compensation to B. That's how certain and final it has to be. And it has to be final, which means the parties agree that it is done. The dispute is done. They should not do anything in furtherance of this anymore. That is what is the meaning of finality. And the implementation has to be possible, must be possible. So it has to be always ensured that a reasonable and a realistic award has been passed. So the implementation has to be possible. You should not say that he has a person who whose earning capacity itself is 50,000 per month. You cannot ask him to pay 50,000 crores. Is it reasonable? Is the implementation possible? The answer is no. But is it within the powers? That might be yes. Maybe the contract has not stipulated the maximum limit of compensation. The compensation shall be as decided by the arbitrator. That doesn't mean arbitrator can decide anything arbitrary. Correct? So the implementation also must be possible. right? So these are the terms, these are the contents of an arbitral award. So now talking about registration of an award, this is very interesting and also time and again tested in exams. Now, what is it? Is it required to register an award? So as I said, attestation, registration and stamp duty. So now I'm talking about the concept of registration. Is it required to register an arbitral award? Do you see a court order being registered? The answer is no. It's an order passed by an authority on the seal of the court, and hence there is no need of a registration. But an arbitral award which is made on a white paper signed by the arbitrator, is it required to be registered? Yes. The answer is yes. But is it always required to be registered? The answer is no. So registration of an award has both yes and no answer. It's not just yes. Yes, when the registration of the award, yes, when the award is dealing with the rights of an immovable property, where that there would be a change in the title or interest of the immovable property. In such cases, since it is an award is an instrument, the Registration Act states that every instrument dealing with the rights of an immovable property, where there is a change of rights of an immovable property of worth more than 100 rupees, it has to be registered. Now, in our lesson 1 itself, lesson 2, we have discussed what is an instrument. An instrument includes all the documents, awards, everything comes under the ambit of instrument. All the deeds also. Sorry, documents include instruments, instruments includes deeds. Now, an instrument is usually a formal document. An award is also a formal document. So, an award is essentially an instrument, right? And hence, since if such award is dealing with the change of rights or title over an immovable property, in such case, yes, it has to be registered. In other cases, no, it need not be registered. Even without registration, an award will still be valid, right? Let's move further. So thanks for watching the video. If you wish to learn more on how to draft, or you want to practice various exercises to sharpen your drafting skills for your examination and also for your practice as a trainee or as a company secretary, please fill in the information in the form which is provided in the description below. We are coming out with a course very soon. Thank you. Stay tuned to Virtualaw, and this is Prakul signing off from VL Academy.